Struggling to pay your child support? Are not receiving any? Need a modification? Has the Department of Revenue filed a case against you? Don't face this alone. If you are dealing with a child support problem, a knowledgeable family law attorney may be able to help you solve it. Let us help so you can focus on being the best parent you can be. Stress less. Choose more.
Good afternoon, everyone. I am Conti Smith. I'm a family law attorney located here in the Central Florida area, and I am excited to have another conversation with one of my favorite family law appeal attorneys. So, Paul, do you want to introduce yourself to our audience?
Sure. Thanks for having me again, Conti. I'm very excited to be here. My name is Paul Shafranski. I am a founder of Artemis Family Law Group. We do a bunch of different family law stuff, but my specialty is in family law appeals.
Awesome. And so last time we got really good feedback from our session, and people wanted some more more information regarding how family law appeals work. So we're going to go into a question and answer session. Are you ready, Paul?
I'm ready.
Okay. All right. So the first question is, the judge ignored evidence about my child's safety. Can I appeal the custody decision?
So broadly, yes, you can appeal a custody decision for sure. Now, the basis for that appeal, the grounds for it, the reasoning is a different story. You can always appeal on evidentiary grounds, meaning if you think the court didn't weigh evidence properly or ignored evidence or made findings that were contrary to the evidence in the record, which is usually the testimony in the transcripts from the hearing. So if you have evidence that showed very clearly that there were concerns about the child's safety and there was not some countervailing evidence saying otherwise for the court to latch onto, then that would be a relatively good ground for appealing that decision.
Okay. My ex lied in court and the judge still ruled against me. Is that enough to file an appeal in Florida?
So probably not. And the reason is it's very difficult to prove that somebody lied in court, that somebody perjured themselves. So you shouldn't do it, but, I know you know this, Conti, people do lie in court, even though you're not supposed to, even though it's perjury, right? People do still lie in court, and it's difficult to prove that they lied. So number one, you're going to have strong proof in the record at the time showing that they lied. But simply the fact that they lied isn't necessarily going to be grounds for an appeal. You're going to have to show that lie, or the court overlooking that lie, actually meaningfully impacted some of the outcome that led to a legal error. Just simply the fact that somebody can lie in court and they still prevail ultimately because there's other evidence in their favor or other factors that go into things. It does not automatically mean you win because your ex lied. It's a tough one to prove.
So let me ask you. Let me ask you this question. So what if someone left off that they had $1 million somewhere in an account on a financial affidavit?
So and you're able to prove, if you're able to prove in court that you do a forensic accounting and you can show that asset does exist, there's proof that it exists, and that it's hard to argue that you forgot about $1 million account. If it's $100 savings account you set up 20 years ago or your grandma set up for you, that's one thing. But $1 million account that you failed to disclose, that would be a strong showing of lack of credibility. And if the court just simply ignored that or said, I'm not really concerned about that information, then you might have something to go on with the appeal. But even that, you're going to have to latch it onto what is the outcome, what in the outcome was actually wrong or erroneous that lie impacted or should have impacted.
Absolutely. Absolutely. All right. So our next question. I think the judge favored my ex from the beginning. Can bias be grounds for an appeal?
The short answer, yes. However, that is one of the hardest grounds to prove on appeal. You would have to have extremely strong showings of bias, not just the court ruled in your ex's favor a bunch of times. Maybe they had better arguments. Maybe they had a better attorney. that doesn't necessarily mean bias. Courts are the judge is a human being, and sometimes they find one person more likable than another, or they respond better to one person over the other. So that bias in and of itself isn't going to really be grounds for a successful appeal. If you have extreme grounds, sure. But ultimately, the court's going to make a decision that's going to leave one or both parties pretty unhappy. It's usually the nature of what we do. One side's going to lose, or sometimes both don't get what they're looking for. And that doesn't necessarily mean bias.
Okay. The final judgment says things that were never discussed during trial. What can I do?
So if the court is including findings that aren't supported by the evidence, that is the testimony in the transcript from that hearing, that trial, then that is grounds for an appeal for sure. You may want to consider also doing a motion for rehearing first, bringing that issue to the trial court's attention first. Hopefully you have those transcripts and you can show the court, you made the following findings, but those were not, we never talked about that at the hearing at all. That didn't come up. It might be that the court, again, I want to emphasize, judges are humans. They make mistakes. They have lots of cases. They might be confusing one case with another. They hear 3 trials in a row, Monday, Tuesday, Wednesday, and they're starting to draft their final judgments on Thursday. They might mix up Mondays and Tuesdays a little bit. That can happen. I try to bring it to their attention first. If that doesn't work, and it oftentimes won't work, even if you're correct, then at that point, yeah, you can appeal it based on the fact that there's no competent, substantial evidence to support the findings in the final judgment.
And Paul, I have a question. So you mentioned a transcript. How necessary is it to have a transcript if you want to file an appeal?
Almost absolutely necessary, unless there's an error that is on the face of the judgment, and that's just fancy lawyer talk for, you can look at the judgment, the piece of paper, and regardless of, without knowing anything else about the case or what actually happened at the trial, you can see an error. Then absent those things, like a math error, the court says 1 + 1 = 12 in the final judgment, when they're doing some of the math for the equitable distribution. That's an error on the face of the judgment. Absent that, anything else having to do with what actually happened at trial, whether something was objected to, what evidence was admitted, what testimony was given, if you don't have a transcript to show the appellate court what actually happened below, then you're pretty much dead on arrival. There's thousands upon thousands of cases that the appellate courts will simply basically do away with an appeal without dealing with it at all because there are no transcripts. It's very, very fatal. So even though I know they're very expensive to order, typically you have to have transcripts in order to do most of your appellate arguments.
Absolutely. Okay. All right. I missed the deadline to appeal my divorce case by a few days. Do I still have options?
No, you don't. That is the harshest sort of rule that we have in appellate world, is the deadline to file a notice of appeal. It is 30 days from the day that the final judgment is issued, or it's 30 days from the date that the court denies a motion for rehearing that is otherwise timely filed. With those two deadlines in mind, if you don't file your notice of appeal deadline in time, it will be dismissed. The court will typically catch that before you even get to the briefing stage of things. It's a jurisdictional deadline, and outside of a few criminal case contexts, there is no remedy for it whatsoever at all. That's why it's the most important one. And whenever I get any consult for an appeal at any stage, I say, has a notice of appeal been filed? When was the final judgment? We need to get on that, because you must file that. Even if you're not even sure if you want to appeal, you file the notice of appeal, and then you can dismiss it later if you decide not to pursue it. But you can't do it in the other order. You can't decide 2 months later that you want to appeal after all. You've got to get that notice of appeal filed in time.
Okay. All right. The judge cut me off before I could finish presenting my case. Is that appealable?
So maybe. The rules are that the trial court has broad discretion and leeway in terms of running their courtroom and running their trials. If you ask for 2 days or let's say 1 day. You ask for 1 day for your trial. And after all is said and done, you only get about half of your evidence in before you run out of time. And the court says, I'm sorry, but you asked for a day and that's what you got, and you didn't present it in time. It's up to you to manage your presentation of evidence and figuring out what's going to be the most efficient use of your time. If at some point during the trial you recognize we're really running late, you can try to ask the trial for additional time. But typically, I would say that's not a terribly strong ground for appealing. Again, you have you can ask the court for any amount of time that you want. Obviously, it's harder to get 4 days for a trial than it is to get 1 day. But if the court says you asked for a day and you got a day, there's not that much to do with that.
All right. My attorney made serious mistakes during trial. Can I appeal because of an ineffective representation?
So this is why it's very important to get good trial attorneys like you, Conti, because there is not really a constitutional right to effective assistance of counsel in the family law world outside of termination of parental rights. It's the one exception we've got, really. Otherwise, effective assistance of counsel is really a rule in the criminal world. But in family law, you get the attorney that you hired, and the job that they do is the job that they do. You may have a private cause of action with them or against them for something, but in terms of appealing it for ineffective assistance of counsel, no, that's not really going to go anywhere at all. Unfortunately, you are stuck with the mistakes that your trial attorney made, and the other side will benefit from them, and vice versa.
It's harsh.
Yeah, it is.
The reality of it. The reality of it. All right. So the parenting plan gives my ex almost all the time sharing, even though we agreed to split custody. Can this be challenged?
Yes, / maybe. So the court ultimately has the responsibility and is tasked with making decisions that are in the best interest of the children, regardless of agreements that the parents have entered into. So it might be that the parents agreed to split custody, do an approximate 50-50 type of schedule, but the reality based on the jobs that the parents work, how far away they live from each other, the schools that the children attend, and other logistical issues, it may be that the court thought there's no way for this to be an equal time sharing plan. It's not going to work. So I'm going to order something different. And as long as the court explains the reasoning for it and goes through the factors and all that, then you can certainly challenge it, but it's not automatically going to be reversed because you both agreed to something else. The court is tasked with best interests of the children determinations, and that means the court can override any agreement that the parents made with regard to the children, including time sharing.
Right. Also, people think that they can agree to child support and they can, deviate, and the child support is a right that belongs to the child, not the parents. So
correct. And that's a calculation that there's a few inputs that go in, income, so a few of the deductions, the time sharing that you're arranging, and whatever number pops out is the number that the parents are responsible for. You can't say, oh, well, I know it says you owe me $300 a month, but let's just put in the agreement $0. That's not how it works.
Not in Florida.
No.
All right. So the court ordered me to pay child support based on the wrong income numbers. Can that be fixed on appeal?
So yes, if there's some type of math error. Now, okay, let me say yes and no. If the issue is I said my income is $500 a week, but my ex is saying that I make $800 a week, and there's contradictory evidence going in both directions, but the court finds it's actually $800, that's an evidentiary determination weighing the evidence type of thing. That's not necessarily the wrong income numbers. That's a disagreement that the court had to decide based on the evidence presented. Now, if everybody agreed that my income was $500 a week, but the court added a 0 in the final judgment and said $5,000 a week and calculated child support based on that number, then yes, that can be fixed on appeal. However, that's the type of thing I would strongly recommend first at least trying to resolve it through either a motion for rehearing with the trial court or a motion to correct a scrivener's error if it really is just a typo that the court made, and try to get that fixed way faster through the trial court directly than going through the arduous, long appellate process to get what essentially may be a typo fixed.
Okay. Yep. I agree with you on that. The judge refused to let my witness testify. Is that reversible error?
Probably not, but it depends on the circumstances. So just like the amount of time available, the court has a lot of leeway over running their courtroom. There's a lot of different reasons why a witness may not be allowed to testify. They might not. They might have cumulative information that's already been heard, and the court's like, I don't need your 17th character witness saying what a good parent you are. I'm good, right? If that's all they're going to testify to. It might be a proposed expert witness, and the court decides, I don't believe that that expert is qualified to testify as to that information. And they might not be allowed to testify in that case. There's a lot of different reasons why a witness may not be allowed to testify. You may not have disclosed that witness ahead of time. You have to disclose your witnesses and the evidence that you're intending to introduce at trial. We don't do trial by ambush in Florida. So that might be another reason why a witness may not be allowed to testify. So it is not reversible error automatically because you weren't allowed to call every witness that you wanted to call.
All right, great. Well, we went through 10 questions today. I think this was very helpful. We'll come back next month because we received a lot of questions last time that we went live. So I'm sure we'll receive more. And we didn't get a chance to answer all the ones that we received from last time. So hopefully in the next month, we can get everything scheduled. Paul, if someone needs help with an appeal, how can they reach you so that you can assist them?
Sure, they can reach out to me. They can go to our website, artemisfamilylaw.com, and they can click on schedule a consultation. They can call the number on the screen, 407-734-2914, and schedule a consultation with me to talk about their next possible steps for an appeal.
Awesome. And if anybody needs help with a family law issue in the Central Florida area, please give us a call at Conti Law. You can reach us at the 407-831-0203. And I also want to shout out Amina Turner. She recently passed the board certification exam for family law. And so less than 2% of the attorneys in Florida are board certified. And Amina Turner is now a board certified attorney in marital and family law here in Florida. So we are excited to have her on the team and for her to be board certified. So shout out to Amina.
Congrats, Amina. That's a huge accomplishment.
She studied really hard, so we are
sure.
really proud. We are really proud of her. But Paul, we appreciate you going live with us. Let's do it again next month. And again, if anyone has any sort of appellate issues or concerns, I love Paul. We send a lot of referrals to Paul, and he does a great job. So please reach out to Paul. Paul, thank you for joining us.
Thank you for having me.
Thanks.